Good morning to everybody. For those of you who are on and joining us today, I'll just offer a few comments before I get into the substance. But I mean, as Daniel mentioned, I practice in several areas, but without question of all the things that I do, this particular topic and transaction is my absolute favorite. I mean, you are stepping this morning into a tremendous world of really, really great people like Steve, Daniel, Tiffany, Mark, and others. There's a fantastic community that's been alive for a while in Texas, conserving the great places in Texas, but it's really growing. In the last 7 or 8 years, I've seen a real increase in interest of Texas landowners as we see cities growing out, fragmentation and loss of special places. More and more people are becoming interested in this conservation easement tool, like Steve's image of the older man on the edge of the river contemplating. All of us in a lot of ways in Texas are that man standing on the edge of something, thinking about what's going to be left in 10, 15, 20, or 50 years. And this tool that I'm going to give you some of the high points this morning is really the only tool that we have in the law in Texas to ensure that these great places in Texas and the piece of land that you own will remain as it is today permanently. And if you think about it, you can't do that by your will. You can't do it by making your kids promise. There's nothing else that will do it like this particular tool. So let me start walking through this. And you heard that phrase from Steve, a conservation easement. That's what we're going to talk about. And I'll tell you, if this is the first time you've heard this or you don't really know what that term means, don't worry. But also I'll give you a tip here, because I've done this a few times. Don't try to understand everything. Don't be paralyzed by this. Some of it's going to be a little legal. The idea is to give you just enough information to intrigue you to take a step further. These are transactions that don't happen overnight. You just don't run down to the land trust or to the lawyer's office and pop in and say, I'd like to do a conservation easement next week. It's something that takes time because it is a permanent decision. It's something that has to be very balanced and very delicate in regards to how permanent it is. So just take a few pieces of what I'm saying, and if hopefully if I intrigue enough of you with it, you can reach out to either of the land trusts here today or do a little reading on your own. And I'm happy as I walk through this, if there are questions about what I'm talking about, put them in the chat box, and then Tiffany or Daniel will throw them at me, and we can talk about them while we're moving through this. First off, what is a conservation easement? And let me walk through this definition. That it's a voluntary legal agreement between a landowner and a qualified holder. And I'm going to take this in pieces because this one definition probably does more to explain and dispel myths about conservation easements than anything else. But it's voluntary. This is not something the government comes in and imposes, or the land trust or any other group. It is 100% the landowner's decision whether this is something that's a good fit for you, and eventually if it progresses to the point that you are comfortable with all the consequences and dimensions of this, you would then sign this conservation easement, which would be recorded at the courthouse. But I just want to underscore this because I typically get a question to say, well, is the government involved? Is this going to be enforced? And it's absolutely not. It's a decision for you and your family to make. Next part of the definition, that allows the landowner to permanently limit the type or amount of development on the property. And that's a key piece of a conservation easement, is that when it's drafted and about to be signed, what you're going to see in there are very specific prohibitions against certain activities on the property. The obvious one is commercial development. There's not going to be any Walmarts, no parking lots, no condominiums None of that type of stuff. And this document is what precludes it forever. Once it is put in place, no one, no matter how smart their lawyers are, how much money they have, is going to be able to take that property and develop it. Moving on to the next part of the definition, in order to protect the property's conservation and ag values. The other piece of that conservation easement would be very extensive. It's going to talk about the nature of the property, the water features on the property, the grasses, great detail, because there is no one conservation easement. A lot of times I'll have landowners and say, hey, Jim, send me the conservation easement, as though there are just one. But every conservation easement is different because it has to be tailored to your particular piece of property. And it's going to go to great lengths to say, look, here are the elements of my property that we are going to conserve permanently, and then more details about how we're going to do that. Likewise, it preserves ag values. This is a tool that is very dear to agriculture, because once you put one of these in place, it really is not going to impair any of your current ag uses, whether you're raising livestock, whether you have a wildlife exemption and you're using it for deer hunting or simply bird watching. Any of those aspects are going to be permanently preserved. Last piece of this definition is while retaining private ownership of the land. And that's maybe the most important, because I have a lot of people say, well, you know, if I don't want to sell my property, I don't want to give it up. But let me explain this. When you give the conservation easements, you're going to be conveying certain rights to the land trust, and the land trust then is going to become a partner with you regarding the continued enforcement of the terms of that conservation easement, to ensure forever after you're gone that the terms of that conservation easement are going to be kept in force. But you continue to own the property. You will be the record owner of your property, and you're free to sell it to somebody else or pass it on to your children, but you're not giving up any ownership of your property by entering into a conservation easement. You are partnering with that land trust to ensure that the terms of that conservation easement remain. Because let's say you sell it 2 or 3 times down the road and somebody decides, hey, I sure would like to put a strip center in here, and you're gone. But that land trust is the one that's going to step in there and say, no, absolutely not. This conservation easement precludes that. Once it's drafted and put together and conveyed at a closing that would be a lot like a real estate closing, that conservation easement is going to be recorded down at the courthouse, just like any other land record. And that way, that ensures a couple of things. One, that conservation easement, what we call as lawyers, runs with the land, which means no matter how many times that land is sold or whose hands it winds up in, the conservation easement travels with the land. You can never separate the two once it's conveyed. The second piece of filing it down at the courthouse is it lets anyone looking at the piece of property or otherwise maybe moving in next to us or potentially buying it, it's of record. It's going to show to everyone that this property has the benefit of a conservation easement on top of it. A few other details that people often raise, what happens if you still owe the bank some money on your piece of property? Not a problem. But in order for a conservation easement to work its magic, to absolutely ensure that there is no development that takes place on that, the conservation easement has to be number one in the pecking order in terms of interest in the property. So if you've got a loan right now, your bank is probably number one to protect their rights to ensure payment of the loan. And when you do one of these conservation easements, you or your counsel will reach out to your bank and they will do what's called a subordination, which says, hey, we understand this is for the benefit of the tract. We're not harmed by this transaction, and we will sign a document that says our lien is still valid, but the conservation easement is now going to rise to the very top of the pecking order. So just because you have a loan or owe the bank some amount of money on your property in no way is an impediment to doing one of these transactions. Okay, so a little more detail now on what is a conservation easement. What is that document? It becomes part of the title to land. You know, if you can think of maybe your property as a layer cake right now, and there are certain layers there, in this conservation easement, you're going to take a few of those layers, like the ability to build a commercial facility or condos or housing development, and you're going to separate those layers from the underlying ownership. You're going to convey those layers over to the land trust and say that, you know, no one can have those layers anymore because they've been conveyed away. But it still maintains one common interest in the title to the land. You can sell it, gift it. It in a conservation easement in no way prohibits you from passing this on to your children, your grandchildren through your will, or selling a piece of property. You know, many times families that go to the point of putting a conservation easement, the land is so integral to their family, they will probably never sell it. But likewise, there are many people who believe so much in pieces of property and preserving them forever. They may buy it, live on it for some period of time, engage in one of these transactions to ensure that tract is forever preserved, and then they'll put it back on the market. They'll sell it. And there's actually, believe it or not, there's quite a community out there now of conservation buyers, people who are attracted to a piece of property, knowing that there's not going to be any development on that tract. As I mentioned before, the conservation easement, it's binding on all future owners. We like to joke in this world that, you know, the second or third generation, there's always one grandkid that is ornery and maybe a little more interested in money than deer hunting. And too bad for that grandchild. This is going to prevent them. It will be bad news to them. So long after you're gone, it's going to ensure that anybody that owns that property, whether they're related to you or not, they have to abide by that. Because, you know, now is probably a pretty good moment to explain this partnership that I've talked about with a land trust. It's very important in the early due diligence part of doing one of these to reach out to HCLT, Texas Land Conservancy, or one of the other land trusts in Texas, and just talk to them. I mean, they're not going to ask for any money. They're not going to be imposing at all. They're nonprofits who are dedicated to this, so they will be happy to talk to you. They take on a big role here. When one of these transactions is done, they agree to perpetually, forever, take on the responsibility for this piece of property and making sure that it's preserved. So these land trusts are truly remarkable organizations. There aren't any others like them in Texas. To say, hey, our mission is to maintain this area of the Hill Country permanently. So real credit to them for taking on that role. This easement's going to selectively remove rights from the title of the land, like I talked about, for development. Likewise, you know, other aspects, there's some limitations on mineral production I'll talk about in a minute, but it's going to define in great detail what rights have been removed and then what rights are reserved to the landowner. And then lastly, I mentioned every easement is going to be tailored to the property, and every land trust in Texas has got a slightly different personality and slightly different approach to all those things, and each of them somewhat has their own form of a conservation easement. Okay, where does a conservation easement come from? This is the legal part of your Friday morning, but it's provided for. The Texas legislature in the Natural Resources Code has fully permitted conservation easements to be done, and it's provided for by statute. But probably the biggest piece of law that is important to this conversation is, you may be surprised to know, is the Federal Internal Revenue Code. Conservation easements are a creature of the tax law, the federal tax law, and that's for a great purpose. There are some fairly eye-popping and stunning tax benefits to doing these transactions that our speakers, a little later this morning, are going to go into detail on that. So more on that later, but that's why it's in the Internal Revenue Code. Been around for decades and decades, but a conservation easement under the Internal Revenue Code, it's got to have one of these essential purposes up here. And you really only have to have one of these. I'll run through them. Protection of significant natural resources, including water or endangered species. That one is probably what we see day to day. More conservation easements are directed at that one. Protection of historical resources. Tiffany could give us a long discussion on that, but there are many landowners who discover burial grounds, arrowheads, other really neat historical features on their property, and you can do a conservation easement for that purpose, to ensure your property is preserved such that those historical artifacts are forever protected. Public access for recreation or education, that they are used for trails. You probably, if you're a trail hiker, you've probably been over a trail that has been provided for in a conservation easement. You may not have known it. And then lastly, for the growing urban areas that we've got in Texas, open space. That's a big one. As we grow more and more, and certainly during COVID, we know we need more access to open space and green places to take kids. And a conservation easement can fulfill that role too. You can create a conservation easement to provide what amounts to a privately owned park, such that people can come on. I'll mention related to that, just because it typically comes up at this point as a question. People say, okay, this sounds intriguing, but if I do one of these, put it over my 500 acres, am I going to be giving public access to my property? And the answer to that is no. Unless you specifically agree and specifically provide in that conservation easement that I want trails on here, or I want the public to be able to come on my property, or school kids, it's not going to happen. That's a decision that's up to you. So a conservation easement itself doesn't open up to public access. Okay, a few basics here. I mean, we've kind of talked about what this document will be, and that we would have some form of closing when you actually sign the paper. These things ideally take a year and a half, sometimes 2 years. And that may seem like a long time, but I can assure you the best ones are the ones where the parties proceed in a deliberate pace, because they're getting to know one another, and you're making decisions that are going to be permanent to the property. So taking your time. But eventually you're going to wind up in a conference room or somewhere where here's the conservation easement, and you're being asked to sign that, and they're going to go down to the courthouse to convey it. And most real estate closings are pretty dull and boring. Conservation easement closings are more like a real celebration of the property. I have seen some people come to tears at that, just at the joy of preserving that property. It's really that meaningful. But at the closing, there are different ways that you might be compensated for doing this. The primary one up there at the top is a donated easement. When you do one of these projects, you will have an appraiser, and that appraiser is going to appraise your property as it is today. He or she is also going to make an appraisal and look at that conservation easement and say, I'm going to study what rights are you giving away and what rights are you keeping. And then we'll make a calculation and say, well, this is the market value that you are giving away if you sign this piece of paper today. And if you do 100% donated easement, that value that you're giving away is going to generate a tax deduction that you can use against your income, your federal income tax liability. So if you're getting no money, you are going to get 100% of the value of that donation that you're making, and then you can carry that out up to 15 years and use it against your income tax. The second is a purchased easement. You know what that value is going to be. There are situations that happen. They are somewhat rare, but we have a couple of good resources for dollars to compensate landowners. One is NRCS, has an elaborate program, and that's the USDA, where they fund conservation easements either in total or in part. Then secondly, we have a program here in Texas at Parks and Wildlife, which I'll talk about briefly at the end here. And those two sources oftentimes can provide dollars. And then thirdly, the land trust itself may have some funds, but again, these are rare. But you can be paid cash money for the total value that you're giving away. Thirdly is simply a combination of the two, which we do see. Sometimes there are dollars, but they're nowhere near enough dollars to match that value the appraiser has calculated. So you're going to get some money at closing, then likewise you will get a deduction for the rest of it to count back against your income tax over time. So what's this process look like? You know, let's say you're somewhat intrigued by our discussion here this morning and think, okay, this piece of property that I love, my kids love, and I really would like to see if this is something I'm interested in. The first process in the due diligence, do some reading. There's some great materials out there from the land trust we have, or an organization called the Texas Land Trust Council that I have served on the board on. There's some great materials on their website. But the process is the same, whether you're donating the easement or whether you're going to get dollars for that. And as you begin to grow your relationship with the land trust, you're going to work with them, beginning talking about, okay, what's your future goals for the property? What rights do you want to reserve? A couple of key decision points are, one, what we call envelopes. Let's say you've got 500 acres and 2 kids, and you think, well, they may want to move back to this property and build houses here. If you want to provide for an area for your children to build houses on the property, you're going to need to define where those areas are and what size those are. These tend to be 5 acres in size. You know, it's up to you and the land trust to define where they are, but given that this is a permanent transaction, you're going to have to think through that process to say, hey, where do I want those envelopes to be, and define those on a map. Similarly, if your property is an ag use and you think you may want to build barns, working pens, things like that, additional ag structures, you may choose to create an envelope, which is nothing more than a square on a map where construction can take place in the future. Other decision point is what we call a partition, which is nothing more than the ability to divide the property. If you say you've got that 500 acres, you can define in the conservation easement that the property can be divided into separate parcels no more than X times. We tend to see 0 to 3, depending on the size of the tract. These decisions I'm telling you about, the envelopes, however many envelopes you choose and however many divisions to the property you choose, also are going to impact that tax deduction. The fewer rights that you reserve, the higher that tax deduction is going to be. I mentioned the process of the appraisal. I won't go into great detail. You don't really need to know that from where you're at today, but the appraiser is one of the most valuable players on your team in this process, because if this is going to be part of a tax deduction, their calculation and detailed appraisal of the rights you're giving up is going to be critical. Another document I'm going to throw out at you, which is probably when a landowner comes away from that closing table, is the one they're fascinated with the most, is called a baseline report. And when we do these, right before, literally the day of the signature on that conservation easement, There's going to be an expert, could be the land trust, could be somebody, a private consultant, but is going to go out and they will have studied your property in granular detail, so much so that you may have owned it for 50 years, and I'll bet they find things on your property that you don't even know are there. Lost springs, the types of grasses, the blends of grasses. And that baseline is going to be, in essence, an encyclopedia of the property. But it serves an important legal purpose going forward. It's going to document exactly what condition the property is in on the date that you conveyed that conservation easement. And so in the event 20 years, 50 years, however down the road, if there is ever a discussion or dispute as to what condition that property was in, that baseline is what's going to define that. Some other just pieces, if you were looking at one of these conservation easements, you know, the elements in it or the sections in it, you're going to have a purpose clause, which sounds boring, but really that's where you're going to define, look, my property has scenic vistas, my property has critical waterways, my property has springs, or it's in the recharge zone. You're going to define those up front and state the preservation of these areas is the purpose of this easement. Same with conservation values. You're going to say this is why my property is unique and needs to be preserved. Then you'll get into the details of restrictions and reserved rights that I told you about. And then finally, there are administrative sections. And that deals with what happens if that, you know, honorary grandchild from Dallas decides to pull a bulldozer on there and start doing something. These easements are going to define what the legal rights are for the land trust to, you start out writing a letter reminding them, and then they can go all the way, if it gets that bad, to actually go to court to enforce them. It's very rare that that happens, but those rights are there in favor of the land trust. Other aspects, you know, construction on the property, why I mentioned those envelopes is construction will take place within those envelopes, but be prohibited otherwise. So you're going to define, okay, where will the roads be? And once you do a conservation easement, somebody can't say, well, you know what, I think we need to put a house over there. That's going to be prohibited. You know, it prohibits most types of what we'll call surface alteration. Any open pit mining is absolutely prohibited. And, you know, scraping areas, creating unauthorized roads, that sort of thing, are likewise going to be detailed in that conservation easement. But the land uses, as I mentioned, agriculture is all going to be preserved. There'd be no impediment to that. If you have row crop area, that's going to be permitted. Grazing, hunting, there's not going to be any impact to those at all. Surface mining is absolutely prohibited. Oil and gas development, I will, since time is limited, I'm just going to briefly state that you can have oil and gas development on your property and still do a conservation easement. I hear all the time somebody say, well, you know, I do one of these, but I have oil and gas, or I think I may have oil and gas. The two of them can be done together. Now, there are some specific things that have to be done to tie up and restrict the mineral rights such that you don't have just wide open development on the surface of the property for oil and gas. But for today's discussion, understand that one doesn't preclude the other. So if you're in an area that has valuable mineral rights or even production that's in place, you can do it. Groundwater extraction, groundwater is huge nowadays in Texas, not only for use, but there's a thriving economy for groundwater rights out there. Typically, conservation easements are going to have language in them that says, look, the owner and any future owner can utilize all of the groundwater for whatever purpose they choose for the surface of the property, but they are prohibited from pumping that groundwater to sell it for commercial uses off of the property. So it's a good tool for sort of groundwater preservation, if you will. I'll breeze through this. There are administrative sections regarding monitoring and enforcement. The land trust, typically, each one is different, but almost all of them do an annual visit to the property, see how things are going. New landowners to this tend to view this as, whoa, they're controlling, they're going to be acting like the sheriff and telling me what to do. It's just not that way at all. They tend to be a partner in this process, and they'll do a ride around with you, make sure everything's going good, and be a resource for advice. You know, I mentioned the minerals, and I won't go into any greater detail because it's fairly complex. It's much easier if you own 100% of the minerals. If you're in the core of the Hill Country, there is a process called a mineral remoteness letter, and we would retain an expert that would look and say, look, you know, the likelihood of any mineral production here in the Hill Country is so remote, it's negligible, and that will cover the mineral interest risk there, such that you can get your deduction from the Internal Revenue Code. You know, a few other things, you know, almost all of them are perpetual. Legally, you can do a term conservation easement, one that is just for a period of years, but those are really not done very often at all. Condemnation, huge topic here that I wish I had time for, but we don't. I will tell you, a conservation easement itself does not prohibit or prevent condemnation. That's a threat all landowners are facing in Texas, but just because you do a conservation easement doesn't ward off like magic the threat of condemnation. Now, it may convince somebody who's doing a project that, hey, we don't want to mess with that and go a different direction, but it doesn't legally prohibit it. One small exception to that is if you do get an award of funds from Texas Parks and Wildlife as part of your conservation easement process, there's some special statutory language that requires the entity to look at other feasible alternatives rather than coming through your property. So that is valuable language if you do get those funds.
Jim, we've got about 1 more minute before we need to transition to questions.
All right. Well, thanks for the reminder because I love to talk. So thank you for keeping me on track. I talked to you about the land trusts. You've got 2 great ones here today. And if you want to look at others, check the Texas Land Trust Council. You know, the last thing that I wanted to talk about, I'll leave the financial to Margaret and Catherine later, is just, you know, the Texas Farm and Ranch Land Program at Parks and Wildlife. It's really a pretty neat program. They divide up $2 million of state funds each biennium, and then grant those projects out, and then use those leverage dollars to ensure we're conserving more and more of Texas. There's some selection criteria, and this will give you an idea of the broad array of where we're preserving properties all over the state using those state colors. So, you know, maybe with that, I'll stand up for any questions if there are any, Tiffany or Daniel.
We have got plenty of questions. I'm going to pose one, and then I'm going to turn it over to Tiffany to ask the rest. The first question comes from Paula. Can a conservation easement be applied to a 10-acre tract within the Fredericksburg ETJ? That land is planned to be a nature park in 20 years, planned by an owner in her will.
Yeah, great question there, which has several pieces to it. I mean, how can you do one that is for a tract that is small in size? And the answer is yes. I mean, legally, there is no minimum size on a conservation easement. You know, 10 acres, it certainly can be done. You have to sort of, that's something you would be working with the land trust, say, hey, is this 10 acres so critical? And of course, it sounds to me like it is. It's headed to be a park. It's in Fredericksburg. That kind of thing is in short supply. So really, the answer to that is yes. It is entirely appropriate to do one of that size.
Thanks, Jim. That kind of addressed one of my questions that I see in the chat as well, asking about minimum acreage, but also about minimum value. And I think the answer is really the same there. You agree?
Oh, yeah. I mean, absolutely. I mean, yeah. If you go out to Trans-Pecos, far west Texas, then, you know, somebody's probably not going to do a 10-acre conservation easement. But if you get into Austin, Dallas, Fredericksburg, 10 acres, number one, is very valuable from a dollar perspective, but it's also very valuable in terms of preserving that acreage in that environment. So good question.
Great. And then another one of the questions that we received, you have you answered, but I'll go ahead. There's a second one that's related. So the first one was, can eminent domain be used to take and change the use of land that has a conservation easement on it? You addressed that. And then someone else asked, please define condemnation.
Condemnation, if I use the word eminent domain, that would probably be those two words mean the same thing. But what that means is that's the law that allows the government, let's say Texas, the city, the county, or even private entities like pipeline companies, electric utilities, or others to come in and forcibly take an easement across your property, or take some portion of your private property and put it to use for one of their projects. That's what we call condemnation and eminent domain. Those two terms really cover the same thing.
Jim, one more question. It's a big question, but what can we expect in the upcoming legislative session in terms of discussions around eminent domain? And then related, you know, a lot of the landowners perhaps on this call have had direct or indirect impacts from the Permian Highway Pipeline. For folks who want to get involved in those discussions around reform of eminent domain, you know, what are the opportunities? Where can they go?
Yeah, a very good question, and I'll try to be succinct, but that's a big topic, but very important. You know, we've all learned, you know, in the last decade, and then with the Permian Pipeline project in the wonderful Hill Country, Wimberley, Fredericksburg, and in between, it's given a lot of people a real bitter lesson in how imbalanced that law is. Definitely going to be an odd legislative session with COVID and the budget. But with respect to eminent domain, I expect you're going to see multiple bills filed by several different sources here to reform these laws in favor of landowners. The demand for this has grown and grown. The last two sessions have been a very, very hot topic. Last session, the TREAD Coalition, if you're familiar with that, had certain bills in the session, and then the private property groups, the Texas Wildlife Association, Cattle Raisers, and Farm Bureau had their own package, which got quite a long ways through the legislature. Those packages are coming back. Those groups are all going to be back demanding protection for landowners. I think one of the primary areas that's going to be requested in light of the Permian is shouldn't pipelines be put over at the Public Utility Commission like transmission lines for routing and such that landowners can participate and question whether the project is even needed or not. So I know a lot of groups are aiming for that this session to say, look, we want a state agency in Texas to be involved looking at these projects before they start coming through our front fence to bulldoze our property.
Jim, thank you so much. For folks who might have additional questions, how do they get in touch with you? Where do they go?
Yeah, great to be with you guys. This is it's fun to do this, but it's fun to do it with friends. So thank you all for having me. You know, if you want to get in touch with me, there's my email down there. I'm not hard to find, so you can email me if you've got another question. And you know, if you guys want, I'll be happy to send you a PDF of the presentation. You guys can flip that out to whoever wants it. So y'all have a great rest of the conference, and I'm going to continue watching.